afternoon or good morning if you're in the US. Thank you, everyone, and welcome. Thank you for joining Covenant Review's Q1 2026 update on covenant trends in European leveraged loans and high yield bonds, including recent LMT litigation. My name's Jane Gray, and I'm the head of European research at Covenant Review. Today, I'm joined by my colleague Shoshana Harrow. She's a senior director at Covenant Review and of the wider Fitch Solutions. Now, in the short 30 minutes that we have today, we want this webinar to be as useful to you as possible. So please don't hesitate to use the Q&A function to ask us any questions as they come up. If we don't get to them in the time we have available, then of course, Shoshana and I will make sure that we get back to you separately. I'm going to hand it straight over to Shoshana now to discuss bond documentation trends in the primary market. I'll then go through some loan trends. We'll talk a little bit about scoring, talk about flex, and then we'll move on to LMTs. Shoshana, passing it over to you.
Great. Thanks, Jane. And hello, everyone. On the bond side for primary, despite really a near shutdown in March, Q1 was relatively high volume for us. And in fact, according to our sister company, LevFit Insights, it was the third largest Q1 volume since 2019. So fairly hefty. Yet again, as has been the case for the last several quarters, last several years, in fact, the vast majority of the high yield deals that came to market this quarter were refi deals. They made up 57% of total volume for the quarter, or rising to 79% if we lump in the bonds that were issued for general corporate purposes. Most of the refi deals were issued to take out existing bonds, although we did see a couple of companies come to market with new money refis to address bank or other debt. And then as for the remainder, just two issuers in the quarter coupled refis with shareholder dividends, and another two issued bonds to finance M&A. LBO deals were not surprisingly a bit thin on the ground as well, but quite high from a volume perspective, thanks to a large euro tranche in the electronic arts deal and the euro portion of the sealed air deal that launched just before the end of the quarter. Now, in terms of documentation, the covenant creep refrain that you're probably familiar with, certainly if you've joined these quarterly webinars previously, well, that applied again this quarter. We saw a progressive loosening of terms to give repeat issuers a bit more capacity in the form of bigger baskets, looser ratios, more EBITDA add backs, more calculation flexibility, things of that nature. While on the new money front, terms were on the whole pretty aggressive straight out the gate. So we saw the typical sponsor-friendly terms like uncapped adjustments to EBITDA, a choice of ratio tests for debt incurrence, lots of no worse ratio tests throughout the covenants where companies can take actions as long as leverage doesn't increase or coverage doesn't decline. Liberal sprinklings of uncapped baskets, lots of pick your poison capacity, leverage-based step downs in the asset sales covenant, and other sponsor-friendly terms. Sealed air in particular, I'll highlight, came to market with a quite nasty provision that would have allowed the company to spin off any business line to represent it up to half of total EBITDA, subject to a ratio test. Now, fortunately, that provision was removed prior to pricing, although it turns out it's probably possible for them to do something quite similar using other permissions in the document. So I wouldn't take too much comfort there. And with that, I'm going to turn it over to you now, Jane, to talk about loan covenants.
Just flipping the slide. Okay, so yes, Q1 was indeed a very volatile market. I think we all know that. The year began with a raft of repricings. We were overwhelmed with repricings in the office, and that fell away sharply in mid-February and in March, of course. Now, in terms of activity mix, when we look at the volumes, this data comes from our sister company, LFI. So repricings sat at the largest, which was 36.5 billion in euros. Extensions, 14.8 billion. We know that the maturity wall has been dealt with in the main. Refis, 8.2 billion euros, and M&A LBO activity at 9 billion. Not what we wanted to see, but not disastrous. Of course, of the M&A volume, two of those were the jumbo M&As, electronic arts, and as Shoshana mentioned, sealed air. So in terms of the number of deals, the data set that we have, if we look at new money, is relatively narrow. And we do have credit stats on that, which we would invite you to look at. Now, let's start with doc trends on the repricing side. It's naturally quite a limited conversation because we are looking at just covenant baskets with numerical floors having been reset. Of course, the credits that are able to come and do a repricing are also generally able to reset the fixed amount limb of their covenant basket to their new EBITDA number, and that's something that cleared all the time. MFN resets varied. Sometimes we saw it, sometimes we did it. We do like to see MFN reset. And there was also some drafting nuances around when soft call protection starts to tick in. But of course, 6 months is the standard for soft call in European loans. So there's nothing much to say there. On the new paper deal, it is always more interesting for us. And as Shoshana said, we have to be careful what we say because the terms are very permissive. They have been for a long time, and the market standard has changed over, since over the last couple of years. But this quarter, we did see more flex more often, and some deals were having to revise their terms multiple times in order to get a full allocation. And that is something that we saw more of, and it certainly feels like the pendulum is slightly swinging in favor of lenders. When we look across our data, and we have a series of data called trend lines, it's in the related content. Hopefully, you can see it on the left hand side. I would invite you to have a look at where the data sits. And we can see that there is a tightening of terms this quarter, which I think is a really interesting thing to look at. Now, I'm going to talk a little bit more about flex in a minute, but there's one provision that I think is very interesting, so we'll discuss that. Due to the geopolitical context that we all know, we've seen some new drafting that we wanted to flag, and this is where really looking at the full form documents and looking at the drafting really matters. Since COVID, we've seen provisions that prevent or delay events of default, including grace period extensions. So, what began as temporary COVID specific relief, so for example, an exception to the delivery of financial statements, has evolved into a standing contractual protection applicable to a wide range of external disruptions. For example, unexpected or uncontrollable events such as pandemics, natural disasters, terrorist activity, war, and cyber attacks. I think most of us know that. But more recently, we're seeing an extension of the drafting of what is not considered having a material adverse effect. And that flows through your events of default. For example, things like world events, quote unquote, strikes and travel disruptions. We've also seen more extensive definition of excluded matters from all events of default. Even more recently, there's been a discussion around universal grace period extensions during certain qualifying events. Now, this creates an indefinite procedural freeze on default escalation. This formula extends beyond typical calamities to include tariffs, trade restrictions, I've heard these before, transport disruptions, and a vague reference to periods of government driven uncertainty. Now, these universal grace periods, which we haven't seen clear but have been discussed, would certainly materially change creditor leverage in a downside situation. And as I've said, this wording's not in the term sheets and in the full form documents. So it's really worth making sure that you're looking at those terms. I'm going to move over to the next slide. Now, here's our documentation scores, and here we're just tracking Europe against the US. So the slide shows our composite loan documentation score plotted as a 3-month rolling average. The score captures overall documentation protectiveness, so it's from a lender perspective at any point in time, and how that has changed indeed as market conditions have shifted. The scores are almost comprehensive. We have scored 97% by count and 99% by size of the first lien institutional issues in the JPM index. So it's really good comprehensive data. And as you can see in this quarter, there's been a tightening of terms, so more protective provisions across both markets at a composite level. And again, you can see the volatility which tracks against macro events such as COVID and even the Ukraine invasion. So we can see the pendulum is slightly swinging in favor of lenders. Here, this is documentation flex. As I said, I was going to talk about this, and this is a very interesting slide. We are tracking all flex across all documents, so from early bird through the general syndication stage. This chart is just flexing what is often considered to be the most permissive terms in a leverage loan and how much they are removed by lenders. As I said, either early bird stage or general syndication stage. Now, if we go from left to right, we can see that Cov-Lite, that's not flexed out. That's become the market standard. It's a rather boring thing to say. Uncapped EBITDA adjustments is often flex out, 14% uncapped EBITDA adjustments at early bird stage, 90% of deals that came with uncapped adjustments had to remove it at general syndication stage. Certainly, the European leverage loan market expects to see a cap on EBITDA adjustments. Now, how robust that cap is a different conversation. And we've written up on that recently in our Worst, Better, Best series, which again, I would invite you to take a look at. Another one which actually has been in the market for a long time in Europe, but since it's attracted US attention, we're seeing it flexed more, which is high or highest watermark EBITDA. And that's the idea when EBITDA goes up and covenant goes up. Covenant capacity, goes up permanently, even if EBITDA subsequently goes down. So that's being flexed out more often. Unfortunately, pre-notification requirements on transfers, which makes liquidity even more difficult and sticky in Europe relative to the US. That's only being flexed out a small amount. But by far, the term which is the most flexed, or at least if we put it the other way, what's asked for most is a J-Crew blocker. We can see that 13% of deals which came without a blocker had to introduce it, and then 20% of the deals which came to market without a blocker, 27%, had to introduce it at general syndication stage. So it's really the most asked for thing amongst permissive terms. That moves us on to the next slide, where we talk about drafting dynamics in the LMT context. And certainly the LMT landscape, and that we often talk about the fact that LMTs have now arrived in Europe, is driving primary requests and primary documentation concerns. The three most common asks is, are there J-Crew blocker, CERTA blocker, TRUE blocker? Now, again, we would invite you to look at our research on what you need to be asking for specifically in those blockers. But that's the most common request. And with that, I'll pass it back to Shoshana.
Well, as Jane mentioned, the increase in European LMTs over the last couple of years has really focused people's attention on doc terms in general, and in particular on these blocker provisions. And I would say it's slightly different on the bond side, where other than J-Crew blockers, blockers are more of a post-restructuring phenomenon than they are a feature of primary deals. But in that post-restructuring context, we're increasingly seeing deals that are just peppered with blockers. Many of them are quite narrow in focus, and they're clearly intended to prevent a specific type of LMT, while others are these broader omnibus-style provisions that are aimed at thwarting LMTs full stop. However, and perhaps not surprisingly, given that it's still relatively early days for these provisions, the drafting varies quite widely, and in all too many cases, the blockers prove to be ineffective. And I'd say as a case in point, early in the quarter, in the first quarter of 2026, we covered a drop-down transaction undertaken by Flighterer. They are SVP-backed engineered wood producer. They managed to shift a valuable subsidiary outside the restricted group for their bonds, which released the guarantee provided by those entities, released collateral. They then went on to raise structural senior financing at this newly unrestricted group. And all that happened despite a set of tightened covenants that were put in place in connection with the previous consensual amend and extend transaction. And those covenants left the company with very little capacity for investments in unrestricted subsidiaries and was replete with blockers. And yet this transaction happened. So how'd they do that? Well, they worked around the limited investments capacity by designating some newly formed entities that had little to no value. And they then sold this valuable subsidiary or a 90% stake in that subsidiary, Silicol, that they wanted to move out. They sold that to the unrestricted subsidiaries. So rather than making an investment, which they didn't have the capacity to do, they just sold something to the unrestricted subsidiary. As I said, once the entity was out of the restricted group, the unrestricted parent of that entity incurred some structurally senior debt, which was how they funded the consideration for this sale transaction. And putting debt onto an unrestricted subsidiary, they were able to sidestep the priming debt blockers that had been incorporated into their tighter bond covenants, because, of course, unrestricted subs aren't subject to the bond covenants. None of this required any type of amendment to their bond covenants, and as a result, their omnibus blocker, which lived in the amendments provision and required supermajority consent for changes that were made for the purposes of conducting an LMT, didn't apply. And it seems that the company also took the view that the transaction didn't breach the blocker provision that requires all designation of unrestricted subs to be for bona fide business reasons and not as part of an LMT. They publicized the transaction as something that was done to bolster liquidity and to allow this Silicol business to pursue its own standalone objectives. And we are assuming that they took comfort in the fact that the term liability management transaction in their covenants wasn't defined. So perhaps that supported a narrow view that in order to be an LMT, you've got to refinance or restructure or exchange the existing debt, and that because they didn't do that as of yet, then the designation and the financing didn't happen in connection with an LMT. So all in all, they were able to just sidestep the document's protected features. Now, interestingly, a few weeks later, Maxeda launched a consent solicitation to implement another consensual restructuring. And like Flighter, the amended indenture was full of blockers. So they, first and foremost, they cut out the unrestricted subsidiary concept altogether, which by definition removes the possibility of an LMT with that kind of entity. They also tried to foreclose use of asset sales as a workaround for limitations. They capped disposals to non-guarantors and entities outside the restricted group, although they weakened it a bit with a purpose qualifier. And then there were a host of other blockers on priming debt, indirect RPs, non-pro rata new money deals. So it all sounds good, right? But when you look closely, you can see that each and every one of those blockers could be amended, if not deleted altogether, with simple majority consent. So the protection offered was essentially illusory. And on the whole, while blockers are on the rise by the numbers, as we see it, protection isn't necessarily increasing all that substantially. The drafting matters for the blocker provisions themselves. The amendment provisions matter, and it's something that we still see as having room for substantial improvement.
And while it's just, I'll cut in there just to say that it's the same when we do see blockers on the European loan side. They're always able to be amended or removed with majority lender consent. Now, because majority lender consent thresholds have reduced in European loans from what was traditionally 2/3 to now it's more often than not a simple majority, it does mean the presence of a blocker in and of itself doesn't prevent future LMT scenarios. So it's worth bearing that in mind as well.
Yeah. Now, on the topic of LMTs, during this quarter, the defendants in the selective LMT litigation filed their motions to dismiss the claims, which makes for some very interesting reading. And we've got a report which will be linked in your materials today. As you'll recall, this case was filed by minority bondholders who attacked the transaction on several grounds, most notably raising federal and state antitrust claims. They alleged that the majority group of bondholders who were party to a co-op agreement and the company had entered into collusive agreements, that they engaged in unlawful price fixing, unlawful group boycott. And not surprisingly, both the company and the co-op defendants raised a host of objections to these claims. First of all, they argued that the Foreign Trade Antitrust Improvements Act, which limits the extraterritorial reach of U.S. antitrust laws, bars the claims because the alleged conduct was foreign, the alleged harm was to foreign plaintiffs, and there was insufficient evidence in their view of an effect on U.S. commerce. They also raised the argument that several previous cases have held that creditor coordination doesn't result in an antitrust injury in general. So they pointed to the well-known Sharon Steele case where the court characterized joint activity by creditors facing a debtor as something that's commonly in all parties' interest. They also pointed to the United Airlines case where the Seventh Circuit held that cooperation by creditors who are trying to collect on their debt under a competitively determined contract isn't the sort of activity that the antitrust laws are concerned with. Now, of course, these cases were looking at the question of whether concerted action by creditors caused antitrust injury to the company, not the question of whether collective action by a subset of creditors to exclude minority group of creditors caused antitrust harm to those who got left by the wayside. Whether the court will find that distinction relevant remains to be seen. The defendants also rejected the plaintiff's definition of the markets for the antitrust claims. They attacked the selective debt market as being a single brand and failing to take potential substitutes like other companies' debt into account. They challenged the leveraged finance market as being too broad and imprecise, and again, not considering substitutes like equity or private capital. And in terms of antitrust injury, as the defendants describe it, it's really a case of contractual sour grapes, if you will, rather than market harm. Now, the other really interesting point that was raised in the original complaint was an allegation that the distressed disposal under Selective's English law governed intercreditor agreement breached the minority protection principle under English law. Now, this is a common law principle that's been developed through judicial decisions. And broadly speaking, it says that majority power has to be exercised in good faith for the benefit of the class as a whole, and not in a way that's oppressive to the minority class members. The plaintiffs referred to this principle to support their claim that the ad hoc group should have mitigated loss for the entire class and protected value for all of the existing bondholders. So on this point, the defendants engaged a former president of the UK Supreme Court, Lord Neuberger of Abbotsbury, to chime in. His view is that the principle is not an overriding one like the plaintiffs claim. According to Lord Neuberger, it's an implied term and it cannot apply if it's inconsistent with the express terms of the contract. In other words, if the contract gives you this explicit right to exercise majority powers in a particular way, then those terms occupy the field, as he put it, and the minority protection principle doesn't apply. Leads to some really interesting thoughts on our part as to whether the fact that these express terms, which we acknowledge are on the page, are being used in the way that they were intended. Because of course, as you know, the distressed disposals are now being used. Were never intended to be used to force a sort of intra-class restructuring in type of coercive LMT that we're seeing now. So we're keenly interested in the way this matter is dealt with. Lord Neuberger also addressed the plaintiff's argument that a tiny clause hidden in the construction section of the intercreditor agreement was useful to the plaintiffs. So that clause says if there's a conflict between the bond indenture and the ICA controls, unless that would present a material risk of liability to the directors, along with some other exceptions. Lord Neuberger argued that this clause is a shield for the group, for the officers, for the directors. It's not a sword for creditors. And of course, the company's lawyers argue it, and we are sympathetic that I think that tucking a point into a parenthetical in that kind of fashion is not how you would allocate rights of that magnitude. So basically, it's an argument that the plaintiffs want the fine print to withstand too much weight. So that's where things stand at this point. The ball is now back in the plaintiff's court. Opposition is due on the 27th of April. So watch this space.
I think that's it. Yeah, no, I've got just one question that I think we have time to answer, but I think, depending on how Selector and this litigation unfolds, is certainly going to fundamentally require us to revisit how we think amendment provisions protect us in leveraged loans, the use of distressed disposals, and certainly in our office, we are looking at intercreditor agreements very, very carefully as well. It's part of what we do all day, every day, just to make sure that our clients understand exactly how those provisions work and how they interrelate to the SFA. Equally, when we talk about certain protection in Europe, it's really important to understand things like hollow tranches in intercreditor agreements. But one of the questions that's come in is I mentioned earlier that there certainly feels like the pendulum right now is swinging a little bit in favor of lenders, certainly in terms of new money deals, and yes, it's always going to be credit specific, but whether that pendulum has swung in terms of transfer provisions. Now, transfer provisions have been notoriously restrictive in European loans. They are more restrictive than they are in their US counterparts. We see a whole host of overriding provisions that will prevent a transfer or voting subparticipation or some form of subcontract. Now, we do see some flex, so minimum transfer amounts, minimum hold amounts. When they're off market, they'll tend to be flexed down to the market average. Concentration limits, so absolute discretion where a lender would start to hold more than 20% of total commitments. Those kind of things get removed. But there is still a lot in the documents. Deemed consent clauses can feel little bit like a tick box exercise to make sure that they're there. But there's often no requirement for the borrower or the sponsor to act in a reasonable manner, or even if it's there, then what's deemed reasonable is in terms of refusal can be very, very restrictive. And there may be, as I've mentioned before, pre-notification obligations or simultaneous notification obligations with a significant burden on transferees and transferors in terms to make sure that they become lender of record. So it's something that still remains a significant concern for the European market, and we haven't seen a kind of material change in those restrictions. Another question that has just come up, which I'm happy to answer as well, is there a write-up on the FLIDA summary, or is that just provided on the webinar? No, we have a lot of research on FLIDA. Please reach out to us and we can send you all the hyperlinks on all the FLIDA research that we have. Equally, Selector, we have a whole breakdown of those of the LMT as well as the different arguments in the litigation. So with that, final questions come in with regards to private credit. We do look at private credit. There's a vast amount of private credit documents out there, and we see the whole spectrum from very large PIC deals that look like broadly syndicated loan through to very small club deals. And so it's very hard for us to talk about trends within private credit. We do tend to see a few more blockers in private credit, for example, transfers of value down to non-guarantors, often called, and Shoshana, correct me if I'm wrong, Stonegate blocker transfer.
Plural,
is that right?
Plural set.
Yes, plural, right. Another American name. So transfers away from the guarantors into the non-guarantor net. But otherwise, private credit market is vast, and we do cover that as well. So with that, I think we've got to everything we wanted to talk about today. If you have any questions, if you would like any links to any research, please don't hesitate to get in touch with us or with your account manager. We're here to answer any questions. Thank you very much for listening, and have a great afternoon. Thank you.